Okay. Probably give people a couple of minutes. Jen, do you know about how many people we might be expecting?
Let me check real quick.
Okay, I think I'll get started about 12:04, so I'll give people a couple more minutes.
We have 42 registrants.
Okay.
I went through a phase where I was running like full on face things. So I ordered some like fake ones and I liked how they looked, but I just couldn't see myself.
All right, why don't we just go ahead and get started with the introductions just so that we're not cutting into time. So I want to welcome everybody to the New Mexico Family Advocacy Program's 9th 2020 ECHO presentation. New Mexico Family Advocacy Program is a model of respondent parent representation being implemented in the 13th and 2nd Judicial Districts that utilizes interdisciplinary teams of lawyers, social workers, and parent mentors working effectively together to provide quality representation, excuse me, and the advocacy and support families need for reunification or other preferred outcomes in the child welfare system. As participants in our community of practice, you will receive professional development from experts and early adopters of the NMFAP model, learn best practices, and collaborate to solve issues that present challenges to provide quality parent representation in the court system. For today, I will be the facilitator. I'm Andrea Gunderson. I'm one of the lead attorneys in the case, or in the program. Jen, can you go ahead and introduce yourself?
Hi everybody, I'm here for technical support should you need it. Just a reminder to mute and unmute yourself, or if you're on the phone, *6. Have a good session.
Thanks, Jen. And so we know that who is with us today. Please, everyone, enter your name and email in the chat while we go into the workshop. So for today, we have Laurel Nesbitt, who is a staff attorney at Disability Rights New Mexico, where she represents clients with disabilities in matters involving discrimination and other legal rights violations. Before joining DRNM, she worked for a number of years representing clients with disabilities in special education and employment discrimination cases. The learning objectives of today will be 5 different things. Participants will have a general understanding of the history, scope, and purpose of the Americans with Disabilities Act, be familiar with what may or may not qualify a person as a disabled person for purposes of the ADA, know what kind of documentation may be sufficient to support a person's claim that they are a disabled person for purposes of the ADA, have a general understanding of what constitutes reasonable modifications under the ADA and how that differs from reasonable efforts in our cases, and finally have a general understanding of the factors to consider when deciding whether or not to invoke the ADA in a child welfare case. So we will turn it over to Laurel. Thank you for being with us. This is definitely something that we will need to have information about in our cases, and so we appreciate you being here. Go ahead, Laurel.
Well, I do appreciate being here. I'm very happy to talk with you today, and this is an issue of great importance to me, and the work that you do is very important to me. I do want to say right off the bat, yes, I am a staff attorney with Disability Rights New Mexico. Most of what I do there has to do with special ed cases, but I am familiar with Title II of the ADA. In my work in the past, when I've been talking about or litigating issues of reasonable accommodations, it's usually been in employment matters under Title I of the ADA, and we're going to get into the different titles here in a minute. But it is interesting to learn about what some of the issues are from looking at some of the case law in your field about what matters tend to come up. I do want to say in the way of a disclaimer that I'm sort of a stranger to procedures, and so I did. Leslie Jones was very about that process. I've taken a glance at the Child Welfare Handbook from 2018 and an excerpt from the 2019 CYFD parent packet, and just basic materials that give me this much understanding about the procedures that you guys know very well, and things like case plans and permanency proceedings, and yes, this reasonable efforts standard that or requirement that we're going to talk about in relation to reasonable modifications. So I definitely wanted to just say, though, that I am here to learn from you too what the types of issues are that you're encountering, and that I want to leave plenty of time for questions for that. I do have kind of, the other thing I want to say is I have slides that I'm just going to say in advance, and I'm sorry, these slides are very text heavy, but please don't be scared. We're not going to read through all these words. I'm going to kind of zip through them. I just want you to have a resource that you can go back to later and have some actual citations and have some context for some of the things that I'm talking about. So please don't stress out if I'm kind of going through slides, kind of flying through some of these slides quickly. I just want to get to the point where we're talking about some of the specific issues that you guys are dealing with. So with that, oh, the other disclaimer I need to make is I have this clock on the wall behind me here at home that chimes at strange times and for odd numbers of times. So, sorry for that disturbance. I know that'll happen while we're together today. Okay, I'm going to go ahead and share my screen and see if we can see. Does everybody see my slides now? Okay, cool. And if anything weird happens with my audio, please do let me know. I've had some things like that have happened recently too. So, okay. So, again, I'm here to talk today about Title II of the ADA and how it relates to child welfare proceedings, or how it might apply. But mostly to give you an idea of some of the background. I have my information here on the first real slide. and definitely feel free to reach out to me after the presentation at any point if you have some questions or need to be connected with some resources. Okay, starting just with basics about the ADA. Historically, you know, the ADA came out of decades of activism by disability rights, you know, the disability rights movement and activists in that movement. I recently have seen a couple of times a film called Crip Camp, which is available on, I think, on Netflix. And if not on Amazon Prime, I've seen it very recently, but it's well worth watching if you are interested in the development of this law. It's again called Crip Camp, and it's about some of the main activists in this movement. What the precursor to the ADA was Section 504 of the Rehabilitation Act of 1973, and like the ADA, it prohibits discrimination on the basis of disability in programs and activities, or actually like Title II, which we'll be talking about today. It is an anti-discrimination statute, but it only applies to entities that receive federal financial assistance, or FFA. On the other hand, Americans with Disabilities Act of 1990 prohibits discrimination against individuals with disabilities in all areas of public life, including jobs, schools, transportation, and all public and private places that are open to the general public. So the different titles address different types of entities and address different contexts, which we'll go into just a little bit. But it is broader in scope than Section 504, but also an anti-discrimination statute. And then in 2008, the ADA was amended. And we will go into a little bit of the reason why in a few slides, but this was an amendment that was in response to and also overturning sort of a series of Supreme Court decisions that were making it really harder and harder to bring ADA claims because of the increasingly restrictive definition in the case law of what constituted a disability. So the ADA Amendments Act made significant changes to that definition and broadened the scope of coverage. Okay, these are some of the slides I'm really talking about that are very text heavy, and we really only need to sort of glance at these about sort of the, you know, the pieces of this that that are relevant to our discussion. You know, in the findings, you can see as you read through some of this that the focus is on being able to access and participate all aspects of society, that people with physical or mental disabilities, you know, have the right to fully participate, and yet they have been precluded from doing so because of discrimination. There in number 3, you see I have highlighted in green that it's, you know, there is a that access to public services is one of the areas where we want to have access for persons with disabilities. And number 5 there, this is actually, I think, very important language. Individuals with disabilities continually encounter various forms of discrimination, including outright intentional exclusion, the discriminatory effects of architectural, transportation, and communication barriers. Some of those you may have seen in some of your cases. Overprotective rules and policies, failure to make modifications.
Can I please get a 4-for-4 with a spicy chicken sandwich and the spicy nugget?
Somebody's not muted there.
Dr. Pepper, please.
A failure to make modifications to existing facilities and practices, exclusionary qualification standards and criteria, segregation and relegation to lesser services, programs, activities, benefits, jobs, or other opportunities. So you can see that the scope of this is really broad, and it's meant to be very broad. You know, and I like the language there in number 7. The nation's proper goals regarding individuals with disabilities are to assure equality of opportunity, full participation, independent living, and economic self-sufficiency for such individuals. So really the purpose slides, I'm just going to kind of glide right over because you can look at these later if you like, but you get the gist, you know, very broad, very focused on access, very focused on equality of opportunity and participation, ability to participate. So there are 5 titles of the ADA. As you can see, the one that we're going to be focusing on is Title II, but Title I has to do with employment. Title III has to do with public accommodations and services operated by private entities. Title IV, telecommunications. Title V, miscellaneous provisions. And I honestly don't really know much about Titles IV and V. Again, most of my experience is under Title I and also under Title II. And then Title III does deal with private entities having to be, for instance, buildings needing to be accessible. You know, that all was a requirement of ADA. One thing to mention, there's the clock. So one thing to mention is that Title II is enforced by the U.S. Department of Justice. So there are complaint procedures, independent complaint procedures that can be made to DOJ. Title II, this is the actual language from the statute. Subject to the provisions of this subchapter, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. This is obviously the provision that applies to what you guys do. Agencies like CYFD are clearly public entities, and their services and programs or activities are, as we'll discuss later, are to be interpreted broadly. And so your clients should not be denied participation or the benefits of these services by virtue of their disabilities. I also have here just a reference to the implementing regs. So it is, the regulations for Title II can be found at 28 CFR Part 35 if you're wanting to look those up later. And some of those are cited in here as well. In fact, this one right here. This just goes into more detail about the prohibitions against discrimination. As usual, you know, there's more detail in a regulation than in the statute itself, and this gives you some more information on that, but I don't think we need to go through every single piece of this. It's just, again, here for your review later, should you like to look at that. I think, and I meant to let's just go back to it for a second. When we look at this language and where I've indicated, you know, particular terms in green, a lot of these things, particularly what is a qualified individual with a disability, these things have been heavily litigated, and these are and certainly the ADA, the amendment came about as a result, like I said before, of some of these decisions being overly restrictive about the definition of a disability. But our next section here in the presentation is who is a qualified individual with a disability. So there is one thing as we look at the definition is to understand that just by virtue of having an impairment, you're not necessarily a qualified individual with a disability. For purposes of the ADA, your impairment needs to impact you in functional ways. So in other words, the definition here, it says, you know, Title II protects 3 categories of individuals with disabilities. 1, individuals who have a physical or mental impairment that substantially limits one or more major life activities. Very important language, that substantially limits one or more major life activities. Number 2, individuals who have a record of a physical or mental impairment that, again, substantially limited one or more of the individual's major life activities. Maybe the person is not currently presenting with this disability, but has a record of this disability. And sometimes that can be relevant for purposes of reasonable modifications. And then number 3 is another category of disability, but it is irrelevant for reasons I'll talk about later to the issue of reasonable modifications. Individuals who are regarded as having such an impairment, whether they have the impairment or not. So this is actually coming from the Technical Assistance Manual, which I have a link to that manual there on that slide. Okay. This again is from the same Technical Assistance Manual. The word qualified is also a heavily litigated term. To be a qualified individual with a disability, you have to meet the essential eligibility requirements for receipt of services or participation in the entity's programs, activities, or services, with or without, and that's confusing language, I'll talk about that in a second, but with or without reasonable modifications to a public entity's rules, policies, or practices, removal of architectural, communication, or transportation barriers, or provision of auxiliary aids and services. So I've always found that language kind of bewildering, that with or without language, but I think it's important to sort of, it's important to understand that maybe not all people need these modifications, and that's the purpose of the without language, but that you are qualified under the ADA if you can participate and access these services with those modifications, with the removal of these barriers, with the provision of auxiliary aids and services. That's the important thing to remember as we go through this analysis, is that your clients are capable in some cases of being able to comply with their plans if they had these modifications, if they had some changes to allow them to access their the elements of their plans, or other pieces of this process where modifications might be applicable. Okay, again, the ADA Amendments Act of 2008 broadened the definition of disability by modifying key terms of that definition. It expanded the definition of major life activities. It redefined who is regarded as having a disability. It modified the regulatory definition of substantially limits. This is really the big deal from the amendments. It specified, because there were a lot of cases on this, specified that disability includes any impairment that is episodic, or, oh, actually it's really the last one that's more the deal. Let's see, there we go. Oops, sorry. So disability can include an impairment that's episodic, like bipolar disorder, or in remission if it would substantially limit a major life activity when active. And it prohibits consideration of the ameliorative effects of mitigating measures. So in other words, I think there were a lot of cases, for instance, with diabetes, whether diabetes was controlled or not controlled successfully. And there are a lot of cases on this. So the disability is supposed to be considered even though mitigating measures may make that not an impact for that person, with the exception being ordinary eyeglasses and contact lenses. And then with respect to reasonable accommodations, it clarifies that an individual who satisfies only the regarded as prong of the definition of disability is not entitled to reasonable accommodation. And that makes sense. If you remember our three definitions, regarded as was sort of the definition whereby somebody might have been wrongly concluded as to have a disability when they don't actually have a disability. And so it doesn't make sense that you'd have reasonable accommodations or reasonable modifications for someone who does not in fact have a disability. So that's one that you guys don't need to worry about. The first two are more the issue, and really more in your cases, the first definition of a person who in fact has an impairment which substantially limits major life activities. That is going to be what the standard is in the lion's share of your cases. Okay, what's a major life activity? This is a big deal in ADA, and it's very widely misunderstood. That the focus, when you're determining whether there is your client is a qualified individual with a disability, the focus is not on the impairment itself, but on its functional impact on the person. When we look at what is a major life activity under the definition of disability in the regulation here, 28 CFR 35.108, here currently are, and this has been expanded too, here is what's considered to be major life activities, and it does indicate that it's not limited to this list, but this is a pretty good expansive list to work from. Major life activities include caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, sitting, reaching, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, writing, communicating, interacting with others, and working. So really a lot of activities that you can sort of hang your hat on there in terms of things that have been litigated in various cases, and in maybe more in the Title I context, but you would be able to find case law out there on these major life activities, should you need it. And then also major life activities include the operation of a major bodily function, and that's described there as well. But mostly it's this part one, these major life activities that you're going to want to be able to say, hey, my client's learning disability, say, impacts her ability to concentrate, impacts her ability to read, to learn, to communicate. My client's autism impacts his ability to communicate and interact with others, you see. So this is where we really want to be, connecting the dots between the impairment, which is not in and of itself a disability for purposes of ADA, to the impact of that impairment. Okay, and then this is also from that technical assistance manual. This is, I mostly brought this in so we could look at these two illustrations of what I was just saying. A person who's deaf is substantially limited in the major life activity of hearing, just by definition. But a person with a minor hearing impairment, on the other hand, may not be substantially limited for purposes of ADA. And so that's a very case-by-case situation. Illustration 2, a person with traumatic brain injury may be substantially limited in the major life activities of caring for oneself, learning and working, or concentrating, or any other, several of those other, activities, because of memory deficit, confusion, contextual difficulties, and an inability to reason appropriately. So you can see you really have to kind of dig into the substance of, how does this disability actually, how does this impairment actually impact the parent that you're working with? Okay, reasonable modifications. Let me see how we're doing on time here, but reasonable modifications is actually the term that's used, as you can see, in ADA Title II. Reasonable accommodations, I think, is used a great deal more in Title I, but I actually think it probably is a good thing for you guys to think about using the term modifications, because I think it probably evokes more of the sense of what needs to be done in your procedures. I may be wrong about that, but the fact that the services and that are offered in these programs that parents go through, and the processes that they go through, that there need to be modifications made in order for them to be able to access those. Okay, so here is the CFR provision that talks about reasonable modifications. A public entity shall make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless, and this is an exception, okay, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the service, program, or activity. This is what we call the fundamental alteration defense, okay? And of course, this has been litigated quite a bit too. They could say, oh, no, that would completely change what we do, and we can't possibly make that accommodation. We can't possibly modify our program in that way. Whether they can or can't, it is probably something that you can work out in your specific case by looking at case law from other states or something. But it is true that if they can show that it would fundamentally alter the nature of their service, program, or activity, they may get off the hook for having to provide that modification. And then here, this is a really text-heavy slide, but this is from the technical assistance manual, the same technical assistance manual. I mostly wanted to draw your attention to illustration 2 there, because this is the one that is, I think, most germane to what you guys are doing. Says, a county general relief program provides emergency food, shelter, and cash grants to individuals who can demonstrate their eligibility. The application process, however, is extremely lengthy and complex. When many individuals with mental disabilities apply for benefits, they are unable to complete the application process successfully. As a result, they are effectively denied benefits to which they are otherwise entitled. In this case, the county has an obligation to make reasonable modifications to its application process to ensure that otherwise eligible individuals are not denied needed benefits. And then it says here kind of what some modifications might be. Modifications to the relief program might include simplifying the application process or providing applicants who have mental disabilities with individualized assistance to complete the process. So I think this is important to focus on, that in some cases, some of the parents you work with may need different services entirely, but in a lot of cases, it might be the same services delivered differently, if that makes sense. It may be that certain pieces of the process need to be slowed down, need to be repeated, need to be simplified in some manner, need to be delivered in a particular way that accommodates this person's disability. So it may not be that you're asking for different stuff, but that you're asking for the same stuff presented differently. Okay, I just wanted to mention this. I mentioned fundamental alteration already. Another exception that defendants or that agencies will sometimes rely on is the direct threat defense. Direct threat means a significant risk to the health or safety of others that cannot be eliminated by a modification of policies, practices, or procedures, or by the provision of auxiliary aids or services as provided in this other provision. I would imagine that direct threat defenses come up in your line of work quite a bit. I don't know that. Maybe others who can tell me about that when we get into the Q&A section of this, but I would imagine that this might come up, and again, as you can well imagine, there's a lot of case law on direct threat, what is and isn't a direct threat, such that the public entity does not have to make the reasonable modification that's been requested. This is more on direct threat from the regulation, and it sort of describes, I don't really want to go too deeply into direct threat. You can look at this later, but I think it's important to emphasize the part that I have in green there at the end, that you have to consider that, or that the agency has to consider in sort of determining whether this individual poses a direct threat. They have to consider whether reasonable modification of policies, practices, or procedures, or the provision of auxiliary aids or services will mitigate the risk of this direct threat. So it's, again, it can't just be, well, this person is dangerous, this person is a threat no matter what. No, I mean, this is sort of a situation where, again, because the person has a disability and is entitled to modifications under Title II, there has to be a careful process by which the agency considers what reasonable modifications might reduce or eliminate that threat. Okay, here is, in this section, I just kind of want to go into my initial thoughts. Again, having this much knowledge of child welfare proceedings, but my initial thoughts about what could be relevant to the work that you do. I want to draw attention to this resource that I found as I was doing my own sort of inquiries into this. It's a really good, I really do point you to this because it's a good start on this, in addition to what I'm giving today, and has more in-depth information in many ways. It's a technical assistance manual that's available online, published in, I think, 2015 by HHS and the Department of Justice, called Protecting the Rights of Parents and Prospective Parents with Disabilities. And it's specifically about the application of ADA Title II in the context of these types of proceedings. Here is some really good language from that technical assistance manual. Two principles that are fundamental to Title II and Section 504 of the Rehabilitation Act, which you remember we discussed way back in the early slides, is that there has to be individualized treatment, and number two, full and equal opportunity. Both of these principles are of particular importance to the administration of child welfare programs. So looking at just each of these in turn, individualized treatment means that individuals with disabilities must be treated on a case-by-case basis, consistent with facts and objective evidence. In other words, this can't be a matter of stereotyping and broad assumptions about people. It really has to be individualized. Full and fair opportunity, though, is kind of where it's at. I mean, in the discussion that we need to have, because, you know, the idea here is that individuals with disabilities have to be provided opportunities to benefit from or participate in child welfare programs, services, and activities that are equal to those extended to individuals without disabilities. So this could require the provision of aids, benefits, and services different from those provided to other parents, which we talked about. That's, you know, could be different services. And prospective parents where necessary to ensure an equal opportunity to obtain the same result or gain the same benefits, such as reunification. So it could be that it requires different services, or it may also mean ensuring physical or programmatic accessibility or providing auxiliary aids and services to ensure adequate communication and participation, unless fundamental alteration, defense. For example, a child welfare agency must provide an interpreter for a father who is deaf when necessary to ensure that he can participate in all aspects of the child welfare interaction. And that's a, you know, that's a pretty straightforward one. But in other instances, this may mean making reasonable modifications to policies, procedures, or practices, which I see as being probably likely more relevant to what you guys see a lot of the time, unless, again, fundamental alteration, defense. But for example, if a child welfare agency provides classes on feeding and bathing children, and a mother with an intellectual disability needs a different method of instruction to learn the techniques, the agency should provide the mother with the method of teaching that she needs. So it's not enough, and we'll talk about this a little bit more when we start distinguishing reasonable efforts. Maybe they made the effort, maybe they provided this training, but did they make the training accessible? If it is not accessible to this person with this disability, you know, because her disability does not allow her to learn in that way, then although it might be a reasonable effort, it's not a reasonable modification. Okay. All right. So again, this comes from that same really good resource. You know, so there was sort of a question and answer format within this document. If you go and look at it, what is a reasonable modification? You know, again, it may involve enhanced or supplemental training to increase frequency of training opportunities, or to provide such training in familiar environments conducive to learning. For example, child welfare agencies may have a parenting skills class once per week. For a parent with a disability who requires individualized assistance in learning new skills because of her or his disability, child welfare agencies may need to modify this training to allow more frequent, longer, or more meaningful training. So, you know, in other words, this may, again, it's not so much about needing to have a different program or different service entirely, but making it accessible. Okay. This is something that I imagine you guys have a lot of questions about, and this may be kind of where we do a little back and forth when we get into Q&A, because there is the process of how to request and document the need for reasonable modifications. I found a resource online when I was trying to look for Title II, documenting the need for modifications. Disability Law Center Massachusetts had some good suggestions on their site, and I think this is sort of like the ideal. This is what it should be, and this is what this is what the process should look like. I want to tell you that even in glancing at some of our New Mexico cases, I think there are some issues already in the way that the case law has shaped up around this. But I do think that the way that Disability Law Center Massachusetts is framing this is correct. You know, you have to make a request. It does not, the law will say that the request for a reasonable accommodation or modification does not have to be in writing. Of course, it's better if it is, you know. It says if the need for a modification is clear, then the request should be simple. For example, a blind individual needing help locating audio materials in the library. simple, straightforward. But if it's not obvious, if the need for the accommodation is not obvious, there might need to be more extensive documentation, like having a letter from a healthcare provider that comes along with the request. Make the request in writing, date it, and keep a copy. And the public entity may have special forms that can be used to do this. And I don't know if CYFD does. Maybe y'all can tell me if they have any kind of reasonable accommodation request or reasonable modification request forms. I understand, though, that raising the issue in your cases is really a matter of raising it in court. So I do get that part. And that, of course, would be, I would think, normally in writing. And I know we're going to talk about, you know, a template for a motion that can be used, which I think is great. You know, the request can come from someone else, like a family member or service provider. The medical support, there might be the need for medical support in some cases. But again, the reality is, and we'll talk about this in a minute, that under our New Mexico case law, it seems like there really is an expectation that there will be medical support or support in the evaluations that are required throughout your proceedings for the need for reasonable accommodations and documenting the disability. This last piece I think is very interesting. And this is something I'm familiar with a lot with Title I, the employment cases. Individuals with disabilities should be prepared to discuss their requests with the public entity. This is sometimes called an interactive process. The purpose of the interactive process is to determine what modification the public entity will provide. And in the employment context, you know, you can imagine like you may need a screen reader that costs $5,000, and you're going to say to your boss, I need this screen reader. I have visual impairment, and I need the screen reader that costs $5,000. And they say, you know, we can't really do that one. Can we do this other one? You know, and there's a back and forth discussion about what reasonable accommodation could be made for this person in the workplace that may take care of the access issues. And so it is supposed to be a back and forth process. I don't know in these proceedings whether it's realistic to think that that would happen, but I think I think that is a concept that you guys could really chew on and see if you think that there is the ability to work with the agency on potential accommodations in an interactive process sort of a mode. Because if there is a way to do that cooperatively and collaboratively, that will probably be helpful in your proceedings. All right, so that was sort of the ideal. That's how it's supposed to be. I want to talk about, just for a couple slides here, what it kind of really looks like in the New Mexico case law from my perspective when I've looked at it. And I've only looked at a handful of cases. But a couple of the ones that I have looked at, you know, this Johnny S. case and Jacqueline P. case that I have cited here. You know, that these have to be preserved. You have to preserve issues concerning violations of the ADA. And to do so, the parent bears the initial burden of asserting that the parent is a qualified individual with a disability. And then after that, the parent must create a factual and legal record sufficient to allow meaningful appellate review of the district court decision on the issue. What's a sufficient record is going to be different for each case. At a minimum, however, there must be a request for relief citing the ADA backed by facts developed in the record. So there is going to need to be some real development of the need for an accommodation. Some considerations that I would point to in having looked at the case law and some of the materials that that Leslie Jones provided to me and that I've looked at online. You know, our cases really do indicate that the reasonable modification should be requested as early as possible. And then again, it should be in writing whenever possible as well. But, you know, as early as attorneys or advocates get involved in this process, you know, make that request for reasonable modifications. Do it early, do it often, you know, at all appropriate points in the process. That second point, if there are ways to raise it again and raise it again, then continue to hammer on the point that, yes, this person really does need these modifications in order to be able to access these services and be successful in this plan. The modifications must be individualized to the parent with a disability, although some modifications, like for instance extended timelines, might be more commonly needed and requested than others. So remember that you are focusing on your individual parent that you're working with, but there may be accommodations that you, or modifications that you learn about, like trying to extend out the timeline for satisfying the requirements in the plan, that may apply maybe not across the board, but to a lot of your parents that you work with. So, you know, it's both things. It needs to be individualized, but there may also be modifications that you learn about based on, you know, what persons with specific or individuals with specific disabilities may need, that may have some applicability in other cases. Be specific and clear, focusing on functional needs of the parent. Again, it's not on the impairment itself, it's on what major life activity is limited and in what ways. What modifications to the plan are necessary for that parent to be successful. So you're going to want to connect the dots for the court. You're going to want to connect the dots for the agency. You want to really say with as much specificity as you can what that parent needs. Also, you know, I think that sort of, I don't know if you guys feel this way, but when I think about that, it gives me a little bit of anxiety. It's like, how do I know what what this parent needs? And we're going to talk a little bit about how to go about getting that information. But one thing that helps this is to know that there are a lot of resources out there where you can tap into substantive information about specific disabilities. The next slide is going to address some of those entities, and it's just very, very helpful to tap into local or national resources for that work with a particular with individuals with the particular disability that you may be looking at. And then just generally, wrong direction. Helpful modifications might include teaching skills, like using evidence-based interventions that are specifically signaled as deficits resulting from a parent's disability. So sometimes in the process, you may need to specifically teach certain skills, like for instance, skills having to do with organization, or skills having to do with concentration, that are the result of this person's disability. So that may be a modification that needs to happen. Now, this is what I was just talking about as far as specific resources you might find, you know, for particular types of disabilities. And, you know, this is a very limited list. There are lots of disabilities that you may have already encountered. Brain injury isn't on here, and that's one that I imagine you may have come into contact with. But in terms of disabilities like mental illness, intellectual and developmental disability, and autism spectrum disorder, there are some links there that maybe you could look at. I will say that Bazelon Center for Mental Health Law is also a great resource with some information specific to child welfare proceedings that you may want to check out. But these entities, you know, oftentimes there are people who are local who you can talk to, or there may be information on these web pages that may go specifically to the types of modifications or accommodations that these parents might need, that the parent you're working with might need. Okay. So again, sort of how to document the disability itself and what the parent needs. You know, I can't say enough times you're going to be focusing as specifically as you can on supports and modifications that would be necessary so that the parent can access programs and services. And the best place to start is by asking the parent, you know, what has helped this person in the past? Did they have particular modification or accommodations in school or in their home? You know, what's helped them to function in the past? They may have some of that information that they can provide to you, and likely do. This is maybe less likely. Do they have their own, you know, records of previous evaluations, neuropsychological evaluations, educational evaluations, or whatever that may document their disability and the needs for accommodations or modifications in the past? Remember that one of the definitions of disability is having a record of an impairment which substantially limits a major life activity. So school records, medical records may be very helpful in, and I don't know, this is where I don't really have an understanding of how these evaluations are conducted, but to the extent that you may be able to impact these evaluations by providing records that show in the past what this person needed, that may be a really good source of information. And likewise, IEPs, individualized education programs, or Section 504 plans, which may have been used in school. If the parent or a family member of the parent might have some of these documents, could be very helpful. I will say, just as a little bit of a word of caution, because I do a lot of special education law, just because it's listed as a modification or accommodation in an IEP doesn't mean it's necessarily a good one. And I will say, kind of cynically, that schools don't always make great choices when it comes to those things, but even being able to look at what they did do, usually it's a matter of not doing enough, and sometimes doing the wrong things. But again, you can talk with the parent about which one of these things, which of these modifications that were made in school really did help, which ones were actually really done, and which ones helped or didn't help. Okay, medical documentation, again, it shouldn't be required in all contexts. Again, the Massachusetts Disability Law Center information is correct, but New Mexico courts in these cases seem to kind of expect it. If possible and as appropriate, you need to provide the evaluator with any past evaluations, relevant school or medical records, we already talked about that, and with any information from the parent about what accommodations and modifications have helped in the past. In addition to really what specifically they are requesting now, if they have an idea of what they're requesting now. The documentation must show not only that there is an impairment, and again, I realize I'm a broken record on this, so not just that this parent has autism, but what it needs to describe as specifically as possible the limitations functionally on the major life activities. So things like with autism, communicating, interactions with others, common impact on major life activities there. It should make recommendations as specific as possible about how to make the services or programs accessible. And when I say should, I really am trying to say here that in order to be most impactful in your cases, it would be preferable that the documentation have this information in there. Again, I think there is an argument to be made that, legally, that it doesn't need to include necessarily all these things. Again, the Massachusetts information, but in terms of the likelihood of success of this theory flying in your cases, I think that as specific as the evaluations can be, the more specific, the better. And then the final thing is, again, the parent shouldn't be required to repeatedly provide documentation. It should be that there is a determination made that the person has a disability for purposes of Title II accommodations or modifications, and there shouldn't be a lot of second guessing of that, but I see that happening in some of the cases, which I'll discuss. Okay, the last real point, and actually, you know what? Before we get into reasonable efforts, I might actually just go into and spend a couple of minutes talking about this this one case that I looked at. And again, I want to make sure that I leave time for questions, so I don't want to go into it for long. But Leslie had provided me with a case, State of New Mexico XREL CYFD versus Melody M and Rodney M. And this is I don't know if this was provided to all of you. It's a 2017 expedited bench decision, so it doesn't have precedential value, but by Judge Michael V. Hill. And I really would suggest that you guys, though, take a look at this, because I feel like there are so many problems in here with the way that the court analyzed this woman's situation, this mother's situation. She claimed to have a learning disability. And then when she had the psychological evaluation, the doctor said, well, she could have a learning disability, but she has adequate intellectual ability for basic routine functioning and appears capable of learning and performing typical routine parenting tasks. So she should be capable of doing these things, doctor says, but she's going to have difficulty with sustained concentration, new learning, and complex problem solving. She'll have difficulty coping in situations where she needs to provide organization and structure. And she might need repetitive exposure to new material in order to learn it, help structuring and organizing coping behavior, and domestic violence counseling, etc. So when you read over this, it seems like it should meet the standard that we've just been talking about being specific, being focused on functioning. But instead, the court sort of says, well, she seems to be able to do it, and skips over the functional pieces and the recommendations that are made by this doctor. And then later, there's a requirement that she provides something in writing specifying her qualifying disability and the accommodation she required from CYFD. Why is she now being asked to give something in writing? There's also a point in this decision where, she testified at a hearing, at a permanency hearing, I think, where she had a learning disability, which causes her to learn slower and requires repetition, particularly through visual stimuli like readings or videos, to understand new information. But apparently she was asked what services she needed that she had not been provided, and no surprise, she testified she did not know. But she testified as to what she needed. She needed repetition, particularly through visual stimuli like readings or videos. It's not necessarily that she needed different services, but again, that she may have needed them delivered differently. Okay, so I would just really say, that it would be a good idea if you have that already in your materials to look at that decision. And Leslie may be able to help with that too. That it's just be a good idea to take a look and sort of see where some of this that we've talked about today might resonate. It's like, well, there really needs to be some educating of the courts on what it is to request and have a reasonable modification. And again, so the last point here really is about reasonable efforts and distinguishing reasonable efforts from reasonable modifications. I think, this is a case that's cited a lot, this In re John D case, but we have previously, this sort of, I think, illustrates the problem with courts potentially confusing or conflating the concept of reasonable efforts and reasonable modifications. We've previously noted that the department is not required to prove the reasonableness of its efforts to assist a parent in a presumptive abandonment case, okay, as opposed to an abuse and neglect case. ADA, however, might indeed apply in the section in abandonment cases if if mom could show a defense there. And that goes into an area that I don't really think we need to focus on, but I think what the court seems to be saying here is, because we don't have to make reasonable efforts in a presumptive abandonment case, we also don't need to make reasonable modifications. And I think one thing that was problematic to me about this case is that there's an entire process that came before the abandonment piece of the case, where there were abuse and neglect proceedings and there were reasonable efforts that had to be made. And were those things made, were those efforts and were those services made accessible to this parent? Who knows? It's not really clear from the case. This again comes from that good technical assistance manual. And I just want to emphasize again that, when we're talking about reasonable modifications versus reasonable efforts, and what was just in that last case we looked at about what may or may not need to be reasonably modified. This technical assistance gives the impression that the expectation is that the services that may need to be modified are very broad. So Title II applies to child welfare agencies and court systems. So not just the agencies, but the courts. The services, programs, and activities provided by public entities include, but are not limited to, investigations, assessments, provision of in-home services, removal of children from their homes, case planning and service planning, visitation, guardianship, adoption, foster care, and reunification services. Services, programs, and activities also extend to child welfare hearings, custody hearings, and proceedings to terminate parental rights. So I think that, again, there may be problems in New Mexico case law where the assumption is that Title II of the ADA only applies in some little portion, some little way or narrow way that the entity functions. Really, it should be much more broadly applied. I think you'd want to argue. Here are a few good resources that this is repetition of what I've just said, because there are some of these I mentioned and cited on the slides up to this point, but that technical assistance manual really is a good thing to look at. The Bazelon Center for Mental Health Law has some resources directly on point, and some briefing that Leslie gave me in this case, In Ray Hicks Brown out of Michigan. Really good resources within some of those decisions and amicus briefs about this question. So I know I've run long, but I definitely want to answer any questions that you guys might have and talk about some situations that you may confront in your cases.
So thanks, Laurel. I just want to make a quick announcement for everybody, anybody who needs to get off sooner than we end, to make sure you do the survey. I think Nita Day indicated she had a question in the chat. So go ahead, Nita.
Thank you, Andrea. Laurel, I was wondering, just for clarification, you had proposed a list of what major life activities could be limited. And I just wanted to clarify, is it your understanding that reading is not an exhaustive list?
Yeah, I mean, it's not an exhaustive list, and certainly by the plain language of the regulation, it's not an exhaustive list. But, it's probably, if you're looking for case law to support you, of course, some of those things have been litigated. Those things are activities that you could probably do some searches and find other cases that are on point. But it is not supposed to be an exhaustive list. And I think that it's definitely fine to make arguments that there's another activity that is that could be considered a major life activity in a situation you're looking at. I do think one thing to say about the major life activity of working, and I don't know if this is still the same, but there used to be sort of a complication around the limits on work that, and I don't know that this is still the case, but this is my recollection was that the impairment had to essentially eliminate your ability to work an entire class of jobs. So I'm not saying this very well, but that is something you want to be careful about, making the argument about substantial limitation of working. You want to be careful that you look closely at what that standard requires. So.
And just kind of to follow up on that,
Yeah.
I've had cases where I believe, and this is something that is, to me, a crux, and maybe you could help clarify this as it relates to, if you have any knowledge of the Kevin S. settlement, that I have clients who I believe would be able to reunify and have their children safely in their home if they had DD waiver services or home and community-based services. But it seems like that CYFD has such like this, we don't know how to get that. Yeah. Sorry, we can't help you. Yeah. And I'm going, wait a minute, it's not my client's problem that you don't know how to get that. And so can you offer any insight, because the reality is, and I'm going to be very crass in saying this, is that oftentimes there's a perception of, well, the parent's just too stupid to parent, and therefore they should not have their kids, because no matter what, it can't be safe. And I'm going, wait a minute, it can be safe if you get the appropriate services in place, right. As well as know the resources out there. And unfortunately, I myself don't have those resources at hand either. But I mean, I'm aware that there's ARCA homes that people could parent their children in, and other group home settings and things of that nature. Yeah. And so I'm just wondering, can you talk a little bit about home and community-based, DD.
Yeah, you know, not in any real way, except to just reiterate that I understand that that problem is very real. In fact, when I was talking with Tim Gardner, who's our legal director, about doing this presentation, that is the reason why he said he felt like it was very important to talk about these things, because so often that's the roadblock. It's just you say, well, this is what I need, and they say, well, that would be nice, but sorry, we just don't have it. You know, we don't have it available. And when it comes down to that, I mean, and I confront that all the time in special education cases. You know, it's like, well, the child needs this. You're making the argument that the child needs this in an IEP meeting, but the district is going to define what the child needs in terms of what the district has already, not and not really paying attention to what they don't have that is what the child really needs. And unfortunately, that just means if you're going to be trying to push for something like that, just like in the special ed situation, that might be a matter of making some sort of a whole separate complaint, you know, again, to DOJ and I know, you know, to say that it's really fine to just say that off the cuff, like you guys have plenty of time and resources to do that. But I see that as being sort of a parallel process where you'd have to make that failure to accommodate or failure to modify claim under Title II separately from these proceedings, you know, in order to try to enforce that. Because ultimately, and then ultimately if they can say, well, it's a fundamental alteration, you know, again, if that's a defense that they can rely on, because you know, maybe these services, you know, because they're not available. I don't know. I just wonder if fundamental alteration might come into that too. But I think that would be a separate proceeding you'd have to be doing, because I don't think you're right. I mean, how do you force their hand if they say, well, we just, you know, that sure would be nice to provide to your client, but stinks, we don't have it. You know, there's no way for me to adequately kind of respond to that, and I'm sorry. Yeah.
Thank you.
Laurel, I have a question. Whenever you talked about the documentation and making the requests, a lot of times it's just maybe my observations of my client, and I don't have medical documentation or a psychologist or a psychiatrist documenting what the issues are and what the recommendations are.
Right.
And is that sufficient for me to make that request in court, to just say, I see that my client is having trouble reading. I'm making this request for these accommodations, even though I don't have a medical or some other kind of documentation to back me up?
So again, I would answer that in the sort of sense that I presented those slides. I think it should be, you know, and it particularly the more obvious the disability is, you know, and the more obvious the more obvious the functional effects of the impairment are. Like if you have a person in court who clearly is not able to concentrate or is not able to read or whatever, you know, I mean, certain things should be obvious. But, you know, I would hesitate to say that you'd want to hang your case completely on that. I think whenever possible, if there is a way to document it, even if there's a way to document it with past records, like I said, or, you know, information coming from other people, not your own observations, any way to back that up, I think it's going to strengthen that argument. And I think whenever possible, if there is a way to have medical documentation, whether it's prior evaluations or present evaluations, you know, the problem, of course, is that those things cost money. And so, you know, and I know your clients aren't typically rolling in that. So I don't know what options you would have available there. I just wondered if, and this is maybe a question I have for you guys, you know, when they're having their evaluations as a part of this process, is there a way for counsel to be involved in that and to provide information about so that's, I guess, what I'm thinking is, if there's already an evaluation being done, how can you feed into that? How can you actually prepare your client for that? How can you get information from what they've experienced in the past, in school, at home? Are there people in their lives who could be involved in providing information for that evaluation? That to me would be the opportunity to get it on the record that this person needs these specific modifications.
Thank you. Does
Sure.
anyone else have any other questions for Laurel?
I really do think, just as another comment, again, just to reiterate, I think there is a real tendency of the courts to probably confuse reasonable efforts with reasonable modifications. I don't know if you guys agree with that, but I think that is just something that in your practice you should be very cautious about, and just trying as much as you can to educate courts that that is a different standard. The reasonable efforts that that need to be made for your client, and the documentation of that by the agency are real different from how those very same efforts, or even different efforts, need to be modified in order for your client to access them. That's a real distinction. So it's a shame that the word reasonable is in both of those terms, but I think that whenever possible, I don't know if there are other cases that might make that distinction, either in other states. I just haven't dug that deeply yet, but that's a real, to me, that really puts up a red flag as far as things to be cautious about, trying not to conflate those things.
So Andrea and Laurel, if I could jump in for just a second, because we're just about out of time. I wanted to say a couple of things. One is that we have a lot of good materials. A lot of the stuff, almost everything that Laurel has referred to, will be in the NMFAP resource library. Corey put in the chat the link to the resource library, which is on our website. Included in that are some templates that Barry Porter was kind enough to share with us. And so if you all don't mind, I'd like to let Barry, if you want to share exactly on this topic, what we're talking about is actually bringing this to court, because Barry does have some good experience with that in our cases.
Sure. Well, we get a lot of these people, just like our criminal defense, we have a lot of folks that have it.
Barry, we're having
Barry,
trouble.
we can't hear.
We're having a hard time hearing you, Barry.
I have to actually log off and log back on.
Okay, so he's logging back on. Laurel, I think while we were waiting for him, I've talked to you about this before, but the fact that a lot of times we're a little bit afraid to bring up ADA, because then the department can say, well, because of this disability, they shouldn't be parents. And I think that's something that this group of attorneys has really worked on, turning that thought around. But I'm sure, oh, there's Barry. I'll stop
Hi.
talking.
So you can hear me now, right?
Yes.
Yeah, I don't know why every time I log on to Zoom, it's almost silent. So yeah, I think we have a lot of clients that we can be using this with, and I really liked the point that Laurel made, especially with some of the judges in the second here, well, one specifically, they conflate reasonable efforts with reasonable accommodation, and kind of making that point to the judge is very important. But also, you have to list out the accommodations that you want, right? And so in the motion template, you'll see there's transportation help to get to UAs. Sometimes they need a community service worker, but they can't go get the community service worker on their own. Like CYFD normally just points them to a phone number, says go get it. And we say, no, we want CYFD to drive them to the intake at the community service worker agency and ensure that they get one. And the toughest thing that I've dealt with is GALs or children's court attorneys not agreeing that the person is qualified. So generally I have to put on some evidence and so I ask clients to get their SSI paperwork if they have that, maybe some of their prescription medications, and then have the client testify. Sometimes it becomes obvious when the client testifies that they need special assistance. And these have all been, for me, mental illness folks. I haven't really had so much of a physical one. But I think it's important to be able to back up that they're qualified with evidence. So as much documentation and testimony that you can have, maybe they're treating physician or they're a psychiatrist or psychologist. The rules of evidence don't apply at a hearing like this. I argue that the standard of proof is preponderance. So we just have to prove that they're a qualified individual under the ADA by preponderance of evidence. And then we have to just list out the accommodations and then get the judge to sign an order that lists out the accommodations that we're requesting, and tell our clients to follow up with us if they're not being accommodated. And then one thing, Lauren, that you mentioned about if there's some authority that we could point to for the judges that accommodations is not the same as reasonable efforts. I don't know if there's a case that says something like that, but I think that kind of thing could really be added to this motion. Give it some more beef. That's all I have.
Yeah, I do think that, and I don't have that case law right now, but I bet you anything that's been litigated elsewhere. I bet you anything that, you know, maybe not here in New Mexico, but I bet that distinction has been made. You know, I think that's great. I love the templates. I think that's a great idea to have those out there. And I just, Andrea, to respond to your question that you were asking in the interim when Barry was getting signed back in. I think that's completely at the heart of this, is that, you know, if you think back to the reasons why the ADA went into effect to begin with, you know, to avoid stereotyping and assumptions that people cannot participate, cannot be successful, cannot access these services. That's the discrimination right there. What you want to be able to say is that, and you already know this, but that with these modifications, they can potentially be successful. You know, and we don't know unless we try. We don't know that that parent can be successful unless we try these modifications, and that's the whole point. But I do realize that's awfully idealistic, and that it can be, I'm sure, very sensitive in your cases to decide whether to raise the issue or not to raise the issue, because yeah, this might be the standard, but courts aren't necessarily, and we see already courts don't understand. They want to discount the need for modification and instead go straight to well, this parent clearly has schizophrenia and is never going to be able to keep on track with parenting. So yeah, I see your struggle, and I know that it has to be very much a case-by-case decision whether to raise these things. But to the extent that you can focus again and really hammer on the modifications themselves being specifically geared toward the deficit that's there because of the disability, you know, that's what we need to target. We don't need to just keep on with the other services we provide and pretend that this person doesn't have a disability. We need to confront that head on and realize that if without modifications, the parent is going to lose the opportunity to parent those children. So,
well, thank you so much, Laurel. This is a
very
huge
welcome.
issue in our cases, and you might be hearing from a lot of us. You put your info there, so we'll be calling you.
All right. Thank you.
So thank you.
No, definitely do.
And thank you, Barry, for your insight too. So just a quick announcement, our next ECHO session is a didactic session. It'll be October 20th. And the topic is an introduction to CYFD's new risk and safety assessment tools. So make sure you keep an eye out for that, everybody. And remember to do the survey as well. Anything else, Leslie?
No, I think we're good. Thank you. And thank you, Laurel, so much, and Barry.
You're very welcome. Thanks so much.
I'm putting a case thing. I attended a similar thing for NACC a couple of weeks ago, and I'm putting a case that might talk about the difference between reasonable efforts and reasonable accommodations in the chat.
Awesome. Thank you, Shasta. All right, everybody. Thank you so much. Have a good day.
Leslie, before you close out, just give me a minute.
Yeah, I was wondering that. Just let me know.
Okay, we can go ahead and close out. I just had to talk to somebody on the chat before we closed it out.
Okay. Okay.
Thanks.